Good morning. Thank you for joining us on this live webinar dealing with issues concerning child custody, child maintenance, and divorce. This is the third one. We started the first one on Monday. We had one yesterday and another today. If you would like to watch the others, we dealt quite extensively on the issue regarding child maintenance and child custody. Please go on the Facebook pages and have a look at the previous videos, and you'll be able to obtain some relevant information to assist you. As stated, this topic will be on the issue of child custody, child maintenance, and divorce. We are streaming live on Facebook pages. The only page that I would be able to properly see any questions that you pose would be the Advocate Mohammed Abduroaf Facebook page. Therefore, if you are not on that page, please visit www.abduroaf.co.za/live, and that should take you to the relevant Facebook page link whereby you can pose questions on the issue concerning child custody, child maintenance, and divorce. Feel free to do so, and hopefully we'll be able to assist you in answering any legal questions you might have on this specific topic. There were many questions posed yesterday. Unfortunately, due to time constraints, these videos takes about 25 minutes to half an hour. Therefore, if you have a question, please pose it as soon as possible. So let us begin. We discussed quite in depth, as I mentioned earlier on, the issue regarding child maintenance during the national lockdown. I'll quickly recap that one more time. If a parent cannot afford to pay all the child maintenance as ordered to do so, please approach the maintenance court as soon as possible to have the order relooked at. Basically, you make an application for a variation of the maintenance order. The court will look at all the circumstances of the matter, and then the court should make a decision. If there is no maintenance order in place, please still continue paying child maintenance. If you lost your job, sell property, sell assets, whatever you have, and use that in support of the minor child. You have no legal obligation to maintain another person, the other parent of the child, unless a court ordered you to do so. Therefore, both parents have to be reasonable, and they have to, fulfill the obligation of the principle that both parents have to pay adequate child maintenance and not excessive child maintenance, for lack of a better way of phrasing it. Therefore, if you have any questions, please feel free to pose it. We are on Facebook Live. I am taking questions, and I'll be able to answer it for you. And hopefully from there on, we can go forward. Let's touch today on the issue concerning divorce. The starting point would basically be what happens before you get married. And that would be the issue regarding the matrimonial property regime. We all know, or I presume we all know, that the default matrimonial property regime in South Africa is that of in-community of property. Basically, what that means is that whatever assets, liabilities, debt you have before the marriage of both spouses gets placed into one pot, and that becomes the joint estate. If you marry someone who owes a third party, let's say 10,000 Rand, and you have in your bank account at the date of marriage 10,000 Rand, that 10,000 Rand may be used to pay that specific spouse's debt of that 10,000 Rand. Therefore, if you are concerned about marrying someone, you're concerned about the financial impact it may have should you marry this specific person in community of property, because this person might have a lot of debt, or you may have a lot of debt, and so on, then you may want to consider the other matrimonial property regimes, and I'll mention them in a moment. If you are married in community of property, it's simple. It's one estate. There's no longer two estates. At death or divorce, that specific estate will have to be divided. It's impossible to say that if there's two homes in the joint estate, at death or divorce, one home belongs to the husband and one home belongs to the wife. That's not how it works. You basically own one half of an undivided share of the joint estate. Basically, if you can't come to an agreement regarding what should happen to both those homes, it should be sold and then the proceeds must be divided equally after all the debts have been paid and so on. That's the issue concerning whether or not to get married in communal property. If you want to protect your assets, or if you are concerned that you may get into some financial trouble sometime into the marriage, and you are worried that it might affect the other spouse or it might affect you, then you may want to consider getting married out of community of property. Basically, what that means is there is now two estates. You will retain your estate and the other party will retain his or her estate as separate estates. Whatever debt the specific spouse brought into the marriage will belong to that spouse. So a creditor, for example, a clothing store, will proceed against that specific spouse for whatever debt or whatever account is outstanding or in arrears. That applies to the issue concerning married out of community property. But however, being married out of community property comes with two possible scenarios. The first is out of community property with the inclusion of the accrual regime, or out of community of property with the exclusion of the accrual regime. The accrual regime basically means that during your marriage, if you are married out of community of property, there remains two estates. You own your property, you own your debt, the wife owns her property and a debt and so on. But at death or divorce, then a calculation gets made. Whatever growth there was in the specific spouse's estate, the other spouse will benefit from half that, the growth, the accrual thereof. If you, at the start of the marriage, the husband's estate was 0 and the wife's estate was 0, if the estates are negative, it's still referred to as 0. And at the divorce or at death, the husband's estate is worth 10,000 Rand and the wife's estate is worth 20,000 Rand. If the accrual regime applies, it means that the husband will get half the difference, meaning he will get 5,000 Rand from the wife's estate. So if you add it to 10 plus 20 is 30, divided by 2 will be 15. So each party will leave with 15,000 Rand. You're only entitled to money, so you can't say, I would like to get my spouse's car or a house and so on. You're entitled to the value, the financial value thereof. Obviously, there are ways of calculating the accrual. Certain assets are not included, CPI gets applied and so on. But that's a basic principle. During the marriage, there is two separate estates if you are married out of community property with accrual regime. At death or divorce, whoever made more money or whoever estate has grown during the marriage, the person whose estate has grown less will acquire half the difference. As I said, now there are certain calculations, but if you are considering getting married out of community property with a accrual system, you need to look at the Matrimonial Property Act and you need to understand what the implications there are of, in the sense of what applies to inheritance, donations between spouses and so on. What if there was a motor vehicle accident and you obtain some money? Does that also form part of the accrual? What if I sell my house that formed part of that was mentioned in the antenuptial contract, and I bought another asset with that specific home? What happens with that home and so on? So those are the issues which you have to now understand and discuss and come to an agreement before your marriage. Then there's a third matrimonial property regime, the one of being married out of community property without the accrual system. That's in simple terms a simple what's yours is yours, what's mine is mine at the start of the marriage and at the end of the marriage. So if that specific spouse divorces, then he leaves with whatever he has and she leaves with whatever she has. Obviously, there can be the issue concerning personal maintenance. If the husband wants to claim personal maintenance from the wife, or the wife would like to claim personal maintenance from the husband. So those specific issues can be looked at and dealt with at a specific time. However, out of community property, in my view, if you are a business person and you are concerned about being, getting into financial trouble and you do not want to burden your other spouse, then I would advise getting married out of community property is the best way forward. Now let's move on. So discuss that with a lawyer and come to an agreement regarding what is the best matrimonial property regime for you and your spouse. Now that the parties are married, so today's topic is, let's get back to it, child custody, child maintenance, and divorce. And I had to put down the prelude regarding the issue concerning divorce. If you do not understand what matrimonial property regime we have entered into, you won't understand how the divorce takes place. So in order for someone to get divorced, the marriage has to have broken down. No court of law will divorce a couple who are happily married. It won't happen. They basically say that the marriage has to be broken down, the marriage cannot be saved, and so on. Basically, the normal scenario would be there is no love and affection between the parties. The parties have been living separate for the last many months. Many times it happens that they've met someone else and they no longer want to be together. There is no love and affection and the marriage has broken down. If that is the case, then the court will obviously be able to divorce you. Before I go on, please, if you have any questions, feel free to post it. I'll try my best to answer it. We are dealing with a topic concerning child custody, child maintenance, and divorce. If you have any queries and so on, we would be happy to assist you via this webinar and advise you accordingly. Moving on. Regarding the issue of divorce, if there are minor children involved, the matter becomes a bit complicated because the parties might want to argue and debate or litigate on the issue who gets custody over the child or the children. A court will not grant a decree of divorce unless a court is convinced that the minor children's best interests are being upheld. With minor children, there comes the issue concerning child maintenance, obviously. So if the father has custody over the kids are living with the father, then the mother would have to pay the father child maintenance, depending upon the financial circumstances. If the mother is working, depending on how much money the father costs and how much the kids cost, and so on. That would be the general scenario. Then there's the issue concerning visitation, which I mentioned early on, regarding the kids. The issue concerning if there are any property, the matrimonial property regime. If they are married income into property, the joint estate must be divided into two and split between the parties. If there are pension funds, those pension funds must be endorsed, and so on. If the parties are married with a accrual regime, those calculations must take place, and the list goes on. Getting divorced is not always that simple because we need to look at those specific issues. The children, custody, child maintenance, visitation, guardianship issues, and so on. Propriety issues regarding the accrual regime. It should be simple, but it can be complicated because you have to now work it out, and not work it out necessarily at the time of divorce, but it needs to be discussed. People have to disclose information. You can't work out the accrual calculations if people don't, come to the table and put the financials on the table. So if the husband or the wife has some money stashed away overseas, that forms part of the accrual. It's a calculation that needs to be, worked out. So the same regarding pension funds. If a spouse has a pension fund during the marriage, income into property, of course, the spouses may not have, disclosed that information, so that information has to be disclosed. Therefore, if you want to have a simple divorce in the future, I would say the most simplistic divorce would be if there are no minor children involved and the parties are married out of community property without the accrual regime. Then automatically, the only issue that could possibly come to fore would be the issue regarding alimony, personal maintenance, but most of the time it's not an issue and the parties can just move on with their lives and continue after the divorce. Now that the marriage has irretrievably broken down, the parties know that they want to go on with their lives. The stumbling blocks, as I mentioned earlier on, would not necessarily be the matrimonial property regime, because that's simple, that's worked out already. We know what must happen. The stumbling block would generally be that of the minor children, child custody issues and child maintenance issues. Sometimes parents believe that they have to fight for the kids, and the father might say, okay, during the marriage or the last 3 or 4 years, the kids are quite old. They must probably 10, 11, or 12 years old. He was the one that worked most of the time from home. He's the one that cared for the kids, and he believes that the mother should now leave the home because the house is on his name. They're married out of communal property without the cruel regime, and that the kids should stay with him because the house is closer to the school and it will be best for the kids, and he believes he can care for the kids. Now, those are things that must be discussed, and both parties must come to the table and work something out. You do not want the judge to be the person to make that specific decision for you. I would not advise that to be the case. So those things need to be unpacked and discussed and worked through. What happens to the kids? What happens on school holidays? What happens during the kids' birthdays? What happens on Father's Day and Mother's Day, or the parents' birthdays, the children's birthdays, and so on? It's easy to say the marriage has broken down irretrievably. Yes, those things we can see. The parties do not want to be married to each other. But what happens beyond that? Now the court says he grants you, or the judge grants a decree of divorce. What happens then? These are issues that must be discussed, worked out, unpacked, and dealt with properly. I do not believe that template agreement should be entered into. For example, the clause where it stipulates that the plaintiff will have custody and the defendant will have a reasonable contact. What does that mean? What's reasonable under these circumstances? That this brings up a whole floodgate of debate afterwards, because one lawyer will have interpretation of reasonable. His reasonable might be every second weekend of the school holidays and so on, but it depends on the age of the child. Where the other lawyer might believe reasonable could mean, half the school holidays, yes, but midweek contact as well. Or one parent can collect the child and the other parent should drop the child. So that leaves a lot of issues, a floodgate for litigation in the future if the parties do not come to an agreement regarding that. So sit down with the other party. Yes, the marriage has broken down. Let's work it out from the first of the month to the end of the month, from the first month of the year to the last month of the year, and from primary school, from preschool to primary school to high school and to university if the kids are still of age. Things have to be looked at and it needs to be discussed. And if it cannot be discussed, it cannot be resolved, then unfortunately, because it cannot be resolved, because the parties cannot agree upon who should have custody over these kids, with who the kids should reside with during the day, and so on. The parties can't come to that agreement. Because of that, the matter will have to go to court, and the court will have to litigate on the specific issue. So I advise everybody, those people who are planning on getting divorced, nothing wrong with that, that's how life is. Please sit down with the other party. Do not let the divorce go ahead being, as I say now, opposed, being litigated upon. 2-3 years to finalize, could be longer depending upon the court, the facts of the matter, and the parties, and so on. Thousands of rands get spent on legal fees, and at the end of the day, you would have gotten exactly what you wanted, what you would have entitled to get, but the child is the one that actually loses out in the long run. Thank you very much for watching this video. There will be more videos in the future. Please follow our pages. It's very useful to do that, and we will remind you of the next one. Thank you very much. Have a lovely day.